Good morning everyone. So this is second lecture on emergency, and in the previous one we dealt with national emergency. In this one we will be doing about state emergency. Now state emergency is given under Article 356. Alright, so Article 356 of Constitution, it is based on Section 93 of Government of India Act 1935, right? And this is just then according to Article 356, Precedent Rule can be imposed on any state of India on the ground of failure of constitutional machinery. So that is state emergency. Precedent Rule, it can be imposed on any state of India. In national emergency, we saw there were three grounds: external aggression, war, armed rebellion. Whereas in state emergency, it can be imposed on the ground of failure of constitutional machinery. This thing, failure of constitutional machinery. Now this is of two types. If we understand what is this failure of constitutional machinery in state, it is also known as Precedence Rule. So basically in this, if the president on governor's report, if he or otherwise if he is satisfied that there is a situation which has arisen in that state, or in case that the government can't be carried in accordance with the constitutional provision, then he may issue the state emergency. So if any state's governor through report he conveys the president that in his view the state is not governing properly or constitutionally, and if the president is satisfied that the state governor is not if the president is satisfied, then at that point president can proclaim the emergency in that state, right? Now according to 356, Precedent Rule can be imposed on any state of India on the ground of constitutional machinery. Now this is of two types. First is if the president receives, the second point over here, if the president receives a report from state's governor or otherwise is convinced. So first thing is if he is receiving a report from the state governor, or otherwise if he is convinced or is satisfied that state situation is such that state government cannot carry on the governance. So here, in a situation where he is satisfied that the state government no more can carry the governance according to the provision of constitution, in that case, first thing is on the report of governor, or otherwise if he is satisfied that government is not able to carry the governance according to the constitutional provision, so he can impose the Precedence Rule. So, this can be a ground of failure of constitutional machinery. This is what we say, a failure of constitutional machinery. Then the other one is given under Article 365. Now according to this, as per this article, now read the first point. As per this article, Precedence Rule can be imposed if any state fails to comply with all direction given by union or matters it is empowered to. So again, in the first one, on governor report or otherwise if the president is satisfied. Whereas in the second case, if any state fails to comply with the direction which is given by the union. So if the state fails to comply with the direction given by the union on matters, the union is empowered to. If state cannot comply, then in that case also Precedent Rule can be imposed. So Precedent Rule is when the state government is suspended and the central government directly administers the state through the office of governor, that is centrally appointed. It is called state emergency or constitutional emergency also. So the second point and third point, they clearly tell you what is the meaning of state emergency, what do we mean by when a precedent rule is applied, and what is failure of constitutional machinery in two cases. First one, when the governor is giving the report and president is satisfied. Second one is as per 365. Then moving with the precedent rule, further understanding. What does it say? Now, Parliament approval is necessary for the imposition of precedent rule on any state. Now, there are again some directions through which it can be imposed. So, first one is that parliamentary approval is necessary for imposing the precedent rule in any of the state. Now, it has to be approved in both the House of Parliament within 2 months of its issue. And the other important point over here is that precedent rule is initially for 6 months, for the period of 6 months, and later it can be extended for 3 years only with the parliamentary approval, which has to be taken by every 6 months. So this is some basic requirements or some basic forms. Now here it is written, you can read it. Precedence rule is initially for a period of 6 months. Later it can be extended for a period of 3 years with parliamentary approval every 6 months. Then 44th Amendment to the Constitution. This is an important amendment, and it brought in some constraint on the imposition of the precedent rule beyond a period of 1 year. Now what does it say? It says that precedent cannot be extended beyond 1 year. It says precedent rule, it cannot be extended beyond 1 year unless. So after 44th Amendment, it brought some constraints in imposing the precedent state emergency. Firstly, it simply says that now precedent rule can only be extended to 1 year. It cannot be extended to beyond 1 year only in some cases, unless there is a national emergency in India, then it can be extended beyond 1 year, or if the Election Commission of India, he certifies that it is necessary to continue the precedent rule in the state because of difficulties in conducting assembly election to the state. So in this case it is important. Now, so what happens after this precedent rule is imposed? Now we have understood on what ground it is, what do we mean by state emergency, precedent rule, what are the approvals required. Now what happens after it get imposed? Now the governor, he carries with the administration of state on behalf of president, or even he or she can take the help of state chief secretary and other advisor or administrators whom she can appoint. So governor carries on with the administration of state on behalf of president. Then the president has a power to declare that state legislature's power would be exercised by the parliament. State legislative assembly, it can be suspended or dissolved by the president. And when the parliament is not in session, president can promulgate ordinances with respect to state administration. So I think then this makes it clear that what happens when precedent rule is imposed. The governor, he carries the administration, right? President can promulgate ordinance State legislative assembly could be either suspended or dissolved by the president. Now, it is seen that when is this precedent rule imposed? So, in some circumstances it is imposed, like the state legislature is not able to elect a leader as chief minister for a time prescribed by the state governor. In that case, it is seen that precedent rule is being imposed. Or if there is a breakdown of a coalition in the state government that leads to CM having minority support in legislature, and the CM is unable to prove his majority within that prescribed time by the governor, in that case also precedent rule is imposed. Or if a no confidence vote in legislative assembly, which leads to a loss of majority, or postponement of elections, so many things, right? Yes, this one says about it. So it has been said that precedent rule has been imposed. State legislature, first thing, when he is not able to elect as a leader, as a chief minister, then breakdown of coalition in the state government, a no confidence vote in legislative assembly leading to loss of majority, postponement of election owing to unavoidable reasons such as natural disaster, epidemic, or war, right? Now, when can a precedent rule be revoked? It can be revoked at any time. And it does not require any approval by the parliament. Then there's some misuse of 356. In some cases, I'll be telling you, SR Bomai case is there. Right? Now, Article 356, it gives the central government a wide power to stamp its authority on state government. It was meant to preserve integrity and unity of the country. But it had been used blatantly to oust state government who were ruled by political opponent of the center. Now, understanding that it was first used for the time in 1951 in Punjab between 1966 and 1977, and Indira Gandhi government they used it for 39 times against various states. Right? Now, in SR Bomai case, this case is extremely important. SR Bomai case 1994, Supreme Court put some strict guidelines on imposition of 356 because there was so much of misuse on it. Now, what was that? Firstly, the proclamation of precedent rule, it was subject to judicial review on the ground of malified intention. Right? Now, this proclamation of precedent rule, it was subject to judicial review. The Supreme Court's guideline, it was the first point over here, if you can read from second, this one, the proclamation of subject to judicial review. Then the imposition of Article 356, it should be justified by center. Then the court said that court has the power to revive the suspended or dissolved state government. Court was given so many powers that it was given a power to even revive the suspended or dissolved state government. If any state government is suspended or dissolved, then court was given power to revive it if the ground for imposition is found to be invalid and unconstitutional. Only if the grounds are, if the precedent rule is being imposed, the grounds are invalid and unconstitutional. So proclamation of this rule was subject to judicial review on grounds of malified intention. If there is a malified intention, that's how it was so many times misused. To avoid that, Supreme Court laid these guidelines. Then further, what did it say? That state assembly cannot be dissolved before parliamentary approval for the imposition of Article 356, and only president can suspend the assembly. So only president was given the power to suspend the assembly. Then serious allegation of corruption against the state ministry and financial instability are not ground for imposition of 356. The court said the serious allegation of corruption against the state ministry or any financial instability are not grounds of constitutional failure, right? Constitutional machinery failure. No, it's not. So on these grounds there can be no precedent rule cannot be imposed. Then any action by the state government that leads to the security of secularism, which is a basic feature of constitution, it cannot be ground for use of Article 356, right? Now if you remember that on 6th December 1992, when in Ayodhya Babri Masjid demolition it happened, then there was so much of unrest in the whole country. Many people died in that, and because of that, on 5th December 1992, through Article 356, state emergency, President issued proclamation, and states like Madhya Pradesh, Rajasthan, Himachal Pradesh, the government was dismissed. So President at that time observed that all these states are not obeying the principle of secularism, and secularism is an important principle of our constitution. Right? So in S.R. Bommai versus Union of India, Supreme Court has said the federal structure of India, it can't be compared with the other countries. And president satisfaction on the ground they are proclaiming emergency, that is subject to judicial review. Right? So, the third point, any action by the state government that leads to security of secularism, now on this ground also cannot be a ground for 356, imposing the state emergency. Now any action by state government, this is done, then Article 356, it cannot be used to sort out any intra-party issues in the ruling party. Now if the ministry of the state resign or is dismissed or loses the majority, then government cannot advise the president to impose this article. Now again this thing was important, it got clear through this case that government cannot advise the president to impose this article if any ministry of state resigns or is dismissed or loses the majority, until there are some enough steps which are taken by the governor for formation of an alternative government. If the governor has taken some step for the formation of other alternative government, until then he cannot advise the president. Then the power of 356 is used only in cases of exigencies. It is an exceptional power. So it is an exceptional power. Now there have been so many judgments of Supreme Court that have limited the room for misuse of this article. Now Sarkaria Commission report, it recommended that Article 356 should be used very sparingly and only as a last resort. Now in this report, President's proclamation of the Precedent Rule, it should include reason as to why he thinks the state cannot run normally. Then whenever possible, center should give the state government a warning before imposing 356. And this article should not be used for setting political scores, right? Then commission recommended the amendment of article in order for the president to authorize to dissolve the state legislature only after parliamentary approval, getting the parliamentary approval. Then Punchi Commission, they recommended that center should try to bring only a specific troubled area under its jurisdiction and not more than for 3 months. Now what did this commission recommended? That some amendments should be made to incorporate the guidelines established by Supreme Court in the Bomai case, SR Bomai case, and commission also recommended the provision of localized emergency, which implies the center can tackle issues at the local level without dissolving the state legislative assembly. So yes, this was it about the state emergency. Right? And if financial emergency is seen, which is given under Article 360 of Constitution, under 360 financial emergency, President is again given the power to declare financial emergency if he is satisfied that financial stability or credit of India or any part of its territory is threatened. Then it also has to be laid down before both of the House of Parliament, and it ceases to operate at expiration of 2 months unless it is approved by the resolutions of the houses. Right? Till now there have been no financial emergencies, no occasion of financial emergency has been seen in India. So state and national and financial are clear. National was put for 3 times, state was for so many times, financial for no time. And thank you. So that's it. In the next one we'll be doing about judiciary, union judiciary.